It's being called one of the most employer-friendly policies in the United States, and it is now Florida law. Here to tell us what it could mean for your next job search is Zach Roth, attorney with Ansbacher Law, which we should note is also a WJCT underwriter. Zach, good morning. Thank you so much for being here.
Good morning. Thanks for having me.
So the push elsewhere is to sort of back away from non-competes. Florida is sort of bucking this trend and moving in the opposite direction. Tell us kind of what is happening right now.
Yeah, it was interesting. Last year, the FCC actually put out guidance rule, whatever you want to say, that non-competes were not enforceable. So we went from this potential, there are no non-competes nationwide, to now in Florida, we are twice as strong if you go from a time period as we were before. A lot of states, I think Virginia is one of them, really are loosening the ability to do non-competes. And Florida said, we're going to go the opposite direction and went a completely different way and put in much stronger non-compete protections for employers, not employees.
And so this new law is called the Florida Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth, also known as the Choice Act. And this essentially increases from 2 to 4 years the period that an employer can enforce a non-compete agreement. And we maybe just should kind of remind people what a non-compete provides for.
Yeah, so essentially it means that if you work for me and you have certain skills is really the intent. We could talk about some of the monetary thresholds in that, but if you're a certain skilled person, high level, I can prevent you from going to another business that does something similar for 4 years. And if you think about it, if you're out of the game for 4 years, you're probably out of the game permanently. So it effectively prohibits competition for high level employees.
That's pretty extraordinary. So from 2 to 4 years, and you kind of alluded to this, but this is for high earning employees. And there are thresholds that are set basically who's considered high earning.
Yeah, it has to do based on the county where you're located. And it's essentially double the average salary of your locality. But what's interesting is, if you looked at, just take the First Coast, if you looked at the average salary in Duval and compared that to St. John's and Baker, for example, you might have wildly different numbers. And I think the statute was intentionally drafted very vaguely to kind of give some room to play with things. And I think that could be something that you see is where is the business located as a way of changing those thresholds.
Yeah. And I know that, non-competes are broadly used for, kind of people in television, sort of on-screen talent. It's very common for those people to have non-competes. But what other kinds of industries tend to use non-competes?
You'll have it a lot in management staff of a lot of different kinds of businesses. Anything from a swim school to I don't know. It's just really anything. The one place that it is prohibited specifically in the statute is in healthcare. And then another place that it's prohibited under ethics rules, at least has been historically, I guess there's some question of whether it continues to be with the statute, is in attorneys. Attorneys can't have non-competes. But I would say other than that, it's pretty broad who takes advantage of them. I run into them quite a bit in various kinds of businesses.
And so you talked about this healthcare worker exemption, and that was something that was sort of inserted into this bill as it was moving through. That is because of a perceived, the importance of healthcare workers in this state and sort of the shortages that we're experiencing and a desire not to hinder that particular line of work.
Right. That makes sense.
Yeah. And so, but for other workers, sometimes non-competes are seen as really non-competitive. And there has been a lot of pushback in this state from labor activists and people who are kind of advocating for more freedom of innovation, people who advocate for, fields to be able to expand and try new things. And they believe that this is kind of hampers that.
I think that 100% is the case. If you're talking about locking employees in for 4 years, at that point, you are significantly dampening the market for employees because how many are going to be eligible at any given time within a specialized field? If you're looking, let's say, if you got a tier B position, call it, and someone has a non-compete and you're wanting to hire them for a tier A position, that's a promotion for that person. It's not like you're taking them and putting them in the same position, but they're still not going to be able to take it. And so that exactly does what you're mentioning and just tampers down that competition for labor.
And so one of the changes that this law provides for, we were talking a little bit before the show began, is, previously employers had to demonstrate that there was like a legitimate business interest that was at in peril, trade secrets, something that they would measurably lose if their non-compete was not enforced. But this law changes kind of the assumption of who is entitled to a non-compete. Can you explain what has changed
Yeah,
there?
that was the thing that honestly I was most surprised when I first read the bill, because historically in any type of injunctive situation, you have to prove that you're more likely to prevail, and you have to prove a certain interest, irreparable harm, that kind of stuff. And this completely flips that on his head, and it says that if the employer alleges a violation, the the court shall enter an injunction. It doesn't even provide for a hearing. It says that it will be done without a hearing, and it is the burden of the employee by clear and convincing evidence, which is a higher standard than we have in civil court generally, to prove a certain limited list of items that they can prove to overturn it.
And so essentially, if an employer seeks this injunctive relief, the court is obligated to issue it. And so that is in effect until what point?
Well, that's a real big concern I have, is because it says shall, which means it's mandatory by interpretation, and it doesn't say then that they shall immediately schedule a hearing. For example, in an eviction, it says that the court will move the matter forward on the docket to move quickly. It doesn't say that about this. So, given how busy court calendars are, the court enters an injunction without a hearing, and now I put in my evidence as an employee, and maybe I get a hearing in 3 months, in which time I can't work. Maybe it's 6 months. I don't know. Schedule hearings all the time for routine things, and it's to get 30 minutes. It's 3 months from now. Is 30 minutes long enough to prove something like this? Do you need an hour? Now we're talking 4 months to get a hearing. It's a really interesting aspect of the law that raises a lot of concerns.
Yeah, and things that you think maybe could be challenged somewhere down the road?
Yeah, I have a concern with the idea that the court shall grant an injunction without a hearing, because under just general constitutional due process, the two elements are notice and an opportunity for hearing. You're going to have your notice by the filing, so I think that's going to be met. But if there's no hearing before the injunction is entered and you're taking away that employee's right to work, to me, that is a potential due process issue.
If you're just joining us, we are talking about the impact of Florida's new employer-friendly non-compete law. And if you have questions about how it could impact you, you can join the conversation by calling 904-549-2937 or emailing firstcoastconnect@wjct.org. In just a bit, we're going to break down the costs that Floridians can expect to see from Trump administration tariffs. But for now, we are talking about this new non-compete deal. And one thing that's interesting about it, Zach, is the fact that this became law without the governor's signature, this Choice Act. And that's extremely unusual for this administration. In fact, it's the first time that it's happened. There were three bills that became law. This was one of them without his signature. What do we take away from that? Are there political implications as to why that might have happened? Do we know what might be motivating that?
I think that has to be the explanation, right? And, the governor, he knows, okay, I got it in my back pocket. I don't have to sign this and it's going to become law. So if he supports it, but he's got certain groups that he doesn't want, to be upset that he signed it, he can still let it become law without signing it. It's not like the federal government, for example, where if the president doesn't sign it, it's vetoed. Here it becomes law. And so I think it is obviously a political, for some background, I don't know what it is, but the fact that it took him 6 years to do this, I think indicates that there's something unique here, or maybe it's a changing trend. We'll see. I don't know. We'll find out more next year, I guess, when more bills come.
Yeah. We do know that the Choice Act, this was House Bill 1219, was backed by a Republican mega donor, Ken Griffin. He's the hedge fund manager at Citadel, who's donated nearly $50 million to the GOP. It was also supported by Associated Industries of Florida, which is another big lobby group, and sponsored by St. Johns County Senator Tom Lee. So that was kind of the support behind it. I want to ask you a little bit about, deviating from this national trend, because we know that there are a lot of states that are moving in sort of the opposite direction. California, Minnesota, North Dakota, some places have just outright banned non-competes. Places like, New York and Illinois have got some income-based restrictions or just sort of other restrictions on it. What is the sense of balancing, legitimate employer interests, the need to protect their trade secrets, the need to protect their client lists from, following another high-level employee out the door?
Well, what's interesting about that is Florida has always had a statute that regulated non-competes. It regulated it differently than we currently have. And I don't recall there being significant concern that it wasn't working. You could put non-competes in that were reasonable based on scope and duration, which is generally, I would say, the historic trend nationally is a reasonableness standard in the court's definition. And maybe there's some guardrails on it. And the way the statute used to work is up to a certain time within this time is reasonable based on the nature of the position and the geographic scope and that kind of thing. And so it is interesting that we kind of had the norm, and a lot of the norm is becoming more restrictive on non-competes, and we kind of threw the norm out the window and went with this very vague, broad statute that, other than the income-based restriction, has almost no guardrails on it.
Something else that's covered by this law, in addition to non-competes, is something that's called garden leave, and that's kind of an interesting arrangement. I think to the ordinary person, it might sound a little cushy. It's basically if you leave your job, there's this period during which your employer continues to pay you. You continue to get benefits. You can't compete or get another job in that field. But it sort of sounds like a sweet deal, right? And yet there are some other considerations.
Yeah, I think for the people that those garden leave, agreements are going to apply to, a lot of their compensation is going to be made up in ways other than their salary. Bonuses, could be commissions, also
Mm.
things like that. And not to mention just growth over time. So it sounds cushy that you're going to get locked into your salary, but if you're going to go 4 years with no increases in pay, no bonuses, no commissions, whatever it may be, it actually is fairly restrictive on people that otherwise could have significant financial upside
People who are getting, as you say, bonuses or commissions who suddenly would not get any of that during that period.
and probably no raise for 4 years.
Right. So there have been, some alternatives traditionally to non-compete agreements. There can be sort of non-disclosure agreements, intellectual property protections. I mean, can you sort of run through what some of the ways that companies can kind of control whether they're bleeding employees to other competitors besides non-compete?
Yeah, I would say the two big ones are what you mentioned, confidentiality and non-disclosure. Those are kind of two sides of the same coin. And then non-solicitation. So confidentiality and non-disclosure are pretty simple. You can't share things that you learned while you were working with us with someone else and use that against us. And that can be trade secrets, intellectual property, but it could also be broader than that. And a lot of times it's limited to basically everything except what you would learn publicly or that you already knew when you got
I
here.
mean, why is it that that is not sufficient? That something like saying you can't, solicit competitors or you can't disclose, you have this non-disclosure agreement isn't enough, and that this push for the overall non-compete is taking.
I think you could take the position that that forces you to live in the gray, because how do I prove what you knew before you got here and what you learned through me? And how do I prove that you could have known it publicly versus not? It's straightforward on the recipe for Coca-Cola, for example, right? That's pretty easy. But in terms of, well, this is the way that you do this thing. This is the easiest way to go about this process. Well, I could say, well, I knew how to do that before I got here. That's why you hired me. And the employer says, no, that's what we teach you. So it kind of removes that gray area of the argument and says, you just can't do it.
And we know that, people who were under an agreement before this law took effect in July, they're not covered by this new act. And so there are people who are still covered by the prior law. And that includes people that we're not talking about, lower wage workers who are governed by this, 2 year. It can be very restrictive on, people who don't work in necessarily super lucrative businesses,
Mhm.
people who are like hairdressers,
Right.
people who are like personal trainers.
Yeah, it's very broad. I know an example of a personal trainer who, they're working at a large gym. They don't make that much money, has clients that they've met independent of the gym, got fired because they were working outside of that and had to leave their employment. Other than providing the gym access, I'm not sure that they were providing any unique training or skill to that to that employee that justifies saying you can't do work outside of work.
Yeah, and we talked about the FTC and then also the National Labor Relations Board, pushing for rules that get rid of non-compete deals overall because they're perceived as unfair. And one of the instances that galvanized some of that movement was this Jimmy John's example. That is no longer in effect, but for a long time, until 2016, workers at Jimmy John's had to promise that they wouldn't work at any other sandwich shop within 3 miles, which turned out to be, when you consider every fast food restaurant that sells a sandwich, turned out to cover enormous amounts of territory. And people looked at that and said, we're not talking about trade secrets here. It's a sandwich.
Right. Well, that's something that's interesting because geographic scope is such a huge element of these, right? And 3 miles sounds narrow, but it's not 3 miles on the road. It's draw a circle 3 miles around it. Think about if you were in San Marco and you drew a circle of 3 miles around, you're going to capture a lot of places. Say you're in Jack's Beach, you're going to capture a lot of places. And historically, there's been kind of guardrails, I've used that term a couple times, on geographic scope. But the new statute basically says within a geographic scope identified in the agreement and doesn't say anything about how you put guardrails on that geographic scope.
And so there's not any limit as far as we know on kind of the range that they can claim. I mean, because some businesses, they could say, even if you're based in Florida, that there are competitors all over the place.
I think that's what you're going to end up seeing happen, which is, interesting. Say I work for, we'll use the personal trainer example since we used it. If you're working as a personal trainer in Jacksonville and you move to Charlotte, are you really competing? But the statute doesn't restrict it because it just says within a geographic scope contained in the agreement.
So there are people, as we said, who believe that this is anti-innovation, it, is anti-startup, even anti-worker. But I would guess that there's some people, and certainly, the lobbying behind it would suggest people who think that this will help businesses in Florida succeed in some respect. And I wonder if businesses might be persuaded to, for instance, relocate to Florida because these are such favorable laws.
Well, because there are significant costs to businesses to recruiting and training employees. And so as someone that experiences that, myself, it's hard when you spend a lot of time training someone, invest in them, and then you train them up and then they get poached away. And so that is a legitimate business interest to regulate. And I do think it's going to be desirable that that's going to be something that can be protected in Florida. What's going to be interesting to see is if, in a way, this sparks competition in the non-compete market, if that makes any sense. Because if I'm looking at two businesses, one has a non-compete and one doesn't, and I'm considering where to take a job, if I'm the employee, that's probably a pretty easy decision for me if everything else is equal. So it's going to be interesting how that works. And also, because of these monetary thresholds in the statute, it's going to be interesting because it could result in some people actually getting pay bumps for the purpose of in putting a non-compete in place.
Yeah,
So
explain how that could work. I mean, we said that there's these county by county income thresholds. And so explain what you mean by a bump.
yeah, so let's say you're making 45%, or I guess because it's double, so let's call it 190% of the local average salary. Well, I'm going to the point where I want to give you a raise, and instead of giving you X, which would put you at 198%, I'm going to give you X plus 3%, but I want you to sign a new agreement with me and it's got a non-compete in it. At the 198%, I couldn't do it, but at the 201, I could. And so maybe employers will start to buy non-competes with a little bit of extra increase. It's going to be interesting to see if there's that, I don't want to use the term manipulation, but if there's that trade-off.
Yeah, I mean, there might be an incentive to give a little raise just to kind of put the handcuffs on an employee and prevent that. Departure. So you're an attorney. I guess the question is sort of, what would you, broadly speaking, advise if people are either in this situation or possibly, as you say, facing a circumstance where they might be offered a small increase in order to put them within the threshold of what this law governs?
Well, generally speaking, as an attorney, I always say you should talk to an attorney. Right? I'm never going to tell anyone you shouldn't talk to an attorney. But this is interesting because when it's a brand new law, and it's not just a new law, we have changes to the law every year, but this is a completely new structure. So other than what we have in the statute right now, we don't know how courts are going to interpret this statute and start to implement it. So you're going to go talk to an attorney, and an attorney's probably going to tell you, we are not sure yet. These are the 1, 2, 3 things that are very black and white in the statute. Outside of that, we don't know what the courts are going to say. And so right now, because you're locking yourself in for 4 years, I guess the best advice is you just need to be very, very aware of what you're signing and very comfortable with it before you do it, because you're signing into such a new program.
And if, in fact, this law is somewhat unconstitutional based on what you said in terms of not having the due process, measurement or measures built in, that's not something a judge just sitting on the case would determine, right? That would have to be specifically challenged through a court procedure by someone who's impacted by the law.
Yeah, and I don't know if a case has been filed yet. My assumption is there's already been a case filed to challenge the constitutionality of it. That's the way it typically goes. But yes, it's not going to just be something the court's going to say, I'm not going to do this because I think I have a problem with this, without the person at least raising it. Generally speaking, courts, because you're going to be in a trial court here, trial courts don't like to make constitutional law normally. They like to decide based on the law before them. If they tried to apply a constitutional analysis to every single case before them, nothing would ever happen in their cases. And so trial courts really aren't given the tools to do that. And so just with your run-of-the-mill case, they're probably going to comply with the statute until they're told not to.
All right. Well, Attorney Zach Roth, it's nice to have you back. Thanks so much for being here. We appreciate it.
Thank you for having me. I appreciate it.